Hello, this is Dave Kelley here at Cudro Group with Brian Hogan. We're going to give a short outline of what it's like to argue for Social Security offset against a government plan, against a public plan. Now, fortunately, we've been involved in two cases just in this past week, one in Stark County, the next one will be in Columbiana County tomorrow, actually, on why a Social Security offset should be done. So we wanted to give you a sample. And when Brian asked me the questions, I should explain that Brian and I had been in court for a total together of about 1,600 plus times. When I'm asked the question, I'll start to give the answer, but I'm not going to give every little detail. I'd rather refer overall to the logic that is employed. So Brian's going to start out with skipping the qualifying questions. We'll do that in another session with Joe Minor or some of the other people here. And instead we will focus on why are Social Security offsets done and how do you justify them in court? Thanks, Brian. You're going to ask me questions.
Okay, Mr. Kelley, when was the first Social Security offset case in Ohio?
The first Social Security offset case was done in 1992. It was called Stovall v. Stovall. Diane Stovall was a teacher in Akron, and her attorney argued that part of her pension should be excluded as being a marital asset because none of her husband's Social Security was being thrown into the marital pot. So it was 1992 in Summit County.
Okay, and can you explain what your role in the case was?
Well, actually, I was hired as the expert on the other side to value Diane's STRS pension, which was quite significant at the time. That was my role.
Oh, okay. Well, I have to be blunt then and ask how a hypothetical offset came into being if you were hired by the Social Security covered participant.
Well, the hired is sort of a good question. As people have learned, we're not hired guns. The attorney on the other side who represented Diane Stovall, talented attorney, Randy Lowry of Akron, Ohio, asked me questions about a recent case, a 1990 Pennsylvania case called Kornbleth, in which individual, Terry Kornbleth, a guy, was employed as a psychologist under the Veterans Administration under civil service, which is not integrated with Social Security, while his spouse, Catherine Kornbleth, was a professor at SUNY Buffalo. And they both earned, by the way, about the same amount of money. He was earning $46,000 a year, she was earning $48,000 a year. And in the Kornbleth case, they decided that it was, very specifically, the present case itself establishes the inequity of positions. By inequity of positions, what Kornbleth said was all of the clinical psychologists who worked under civil service, his entire pension was thrown into the marital pot, yet Catherine Kornbleth had part of her retirement benefits excluded, the Social Security. So what the Kornbleth case did was they decided, well, how much of the actual civil service pension would be in lieu of Social Security? So that's how Social Security offsets came into being in the Pennsylvania courts.
So what was it that counsel for that case asked you that set the stage for all of these Ohio Social Security offset cases?
Well, he asked me about Kornbleth, and he asked me specifically, and what was very good was he pointed out this, as the Kornbleth case says, the inequity of positions, how much more money, marital retirement money, that the Social Security plan participant would have than the teacher would have if you did not factor in a Social Security offset. So he just asked fair, logical questions, and he extracted enough information to win on that issue.
Why did it take so long for Social Security offsets to enter the divorce arena?
That's a really long, complex question, and it's actually answered best in a book. There's a treatise called Value of Pension and Divorce, written by Mark Altshuler, an actuary and an ERISA attorney. Nora Kelley happens to be my daughter. And chapter 16 is on Social Security, and it outlines why Social Security did not enter divorce courts until more recent times. And just to give a brief outline of it, basically she points out that in 1960, Fleming versus Nestor, a Supreme Court case, basically said that Social Security were not, quote, an accrued property right, end of quote. So that basically kept Social Security out of the marital arena. But over a period of 20 years, that started to erode with various states, including California, starting to factor using Social Security as a factor, not directly dividing it, but as a factor. That pretty much ended in 1979 when Izquierdo was decided also by the Supreme Court. And in Izquierdo, the court decided that Tier 1 of the Railroad Retirement Act, which is very much like Social Security, was not a marital asset. That put a screeching halt on attorneys trying to use Social Security as a factor. And then from 1979, it's literally another 11 years before you get to Kornbleth, where they use a different way of doing it. Rather than looking at the Social Security, they covered one eye and said, we don't see the Social Security, but we see a component of the public plan, which is in lieu of Social Security, as being sacrosanct, and we can shield that. That's how it crept in.
Okay, so following the Kornbleth case, were there certain treatises or materials that pointed out any problems with the hypothetical approach?
There was a very aptly named article in 1991 in the Family Advocate called Making Social Security a Marital Asset. It was done by Bullen and Deniger. And what they pointed out was that hypothetical was making Social Security a marital asset in a way, but there was a significant hole in hypothetical offsets. What if the two parties, unlike Terry and Catherine Kornbleth, had very unequal incomes? Or let's say that Terry Kornbleth worked under civil service, but Catherine never had earned any Social Security. Would it make sense to take and carve out a large portion of her pension as though it did not exist? And the answer was there was a hole in Social Security. By the way, I should note that in one of the first books I wrote with Gary Schulman on dividing pensions and divorce, we mentioned this problem. And here at Kudrow Group, this has been in our reports for many decades. And by the way, it's a section we will not remove. It's a very important caveat to attorneys that there is a weakness, and it's cropped up more recently in a case I was involved in called Byerly versus Joliet down in Franklin County, where the court was very aware of these flaws in Social Security. Matter of fact, the Judge Dana Price pointed out that if the parties are not of similar ages, similar income levels, there is this problem. And she was also quite aware of how Pennsylvania then changed and refined Kornbleth later on.
So let's talk about that. What was it that Pennsylvania did to deal with the potential problem of fairness in hypothetical offsets?
7 years after Kornbleth in 1997, the Pennsylvania courts decided in McLean that Social Security, hypothetical Social Security, meaning how much of the civil service or the STRS pension is in lieu of Social Security, they decided that there was this potential problem that Bullen and Deniger pointed out in the Family Advocate article, that you could overstate the offset. So that was picked up in the Franklin County case of Byerly versus Joliet.
Okay, now I want to ask, how did the passage of House Bill 395 in 2009 impact the role of Social Security in Ohio divorces?
It's a very interesting element. Of course, it overturned Neville, which was a complex series of calculations of what did a 50% spousal benefit mean, what were the coattail benefits that one might have if one got divorced and one spouse continued working, how much more would your pension increase, what was the widow or widower's benefits. There was a whole panoply of different values that were confusing to courts. So the court decided they still saw the issue of equity in Neville, but the legislature said we want to simplify it. So they passed House Bill 395, which basically brought in into 3105-171, the equitable distribution statute. They brought in section F1 and F9 especially. Let me just read F1. In making a divorce, in F, the header is, in making a division of marital property and in determining whether to make and the amount, if of any distributive award under this section, the court shall consider all the following factors. And then under 9, which is the key section, so it's 3105-171 F9, it says, any retirement benefits of the spouses, excluding the Social Security benefits of a spouse, except as may be relevant for purposes of dividing a public pension. So it says it shall consider, and then as may be relevant. So they must look at the Social Security factor and as may be relevant.
Okay, well let's key in on that word there just for a moment. Can you explain what factors would be relevant in determining if that offset should be done or not?
That's a really key question, because you have some districts, like the 5th District, which has sometimes said Social Security offset need not be done. And I'll give you a fact pattern in one of them where they decided it should not be done. It's when the public pension was Federal Employees Retirement System. Now, the Federal Employees Retirement System is integrated with Social Security, so no offset need be done. There are 39 states in this country which have taken their public pensions and integrated them into the Social Security system. So I would not assume that they should have a Social Security offset there. So the relevant factors are, what plan are we talking about, Brian? And of course the other factor is, how much is the Social Security? Was it accrued during the marriage?
Okay, so are you saying then that a court does not have to consider Social Security when estate plan is involved?
It shall. It's told it shall consider all the following factors. So it shall do it. And then it says, once again, as may be relevant. In my own perspective, as may be relevant, it means, well, if it's an Ohio State pension and there's actual Social Security, that's a pretty good choice that it probably should be done. If it's a Federal Employees Retirement System, no. If it's one of those 39 other states that does integrate the public plans with Social Security, probably not. But it is within the discretion of the court. This has not been clearly defined at any court giving an outline, like you would have a significant Supreme Court case, Hoyt, which establishes proportionate share or coverture.
Okay, so what would be the logical fact pattern where a court would choose not to consider? You sort of mentioned that briefly there if you were working with an FERS plan, but could you just elaborate on that?
Yes, a teacher moves in from a state where the public pension that was accrued during the marriage was integrated with Social Security, not like the State Teachers Retirement System of Ohio Public Employees Retirement System, moves in and then gets divorced. That's one of the cases where you would likely, the fact pattern would, to me, not really justify doing a Social Security offset. Because you want to be looking at apples and apples. You want to be looking at the retirement income earned during the marriage of both parties. And that's one of the factors that we would show in almost any case. We always have an exhibit that shows here's what the parties would receive with the Social Security offset earned during the marriage, and here is what they would receive without the Social Security. And it's so stark, the differences sometimes. One party will receive, the Social Security party, who does not have to have any offset done to the spouse's STRS, might be receiving $4,500 a month, and while the STRS plan participant might be receiving $1,800 a month. It's stark, and those are the issues, once again, that Kornbleth talked about, the inequity of positions. And we try to point out in every case the inequity of income.
Okay, well, I have just one more question, and this actually is kind of going off script a little bit, but it's something that comes up pretty often. What do you do in situations where you have one party who has a state plan benefit but also has Social Security, and the other party has just Social Security? So a situation where each of the two parties has Social Security benefits. What impact does that have on how Social Security offsets are done in Ohio?
That's not really been totally addressed by any court spelling that out. But if you're talking about equity, doesn't it make sense to take a look at the retirement benefits of all the parties? We normally would also do the spouse that is in a state plan. We would also do their Social Security, recognizing that they're going to suffer from something called the windfall elimination provision. I won't go into all the details here. We always have an exhibit book with us with the Internal Revenue Code sections on it and the Congressional Research Service, but there would be a windfall elimination provision. They would lose about half of the first $800 and some odd dollars. And there's also, as you know, the state teacher also suffers from the government pension offset. For every $3 the teacher gets from the state teacher's retirement system, they will lose $2 of their spousal Social Security benefit. So that would be my answer. I'd like to conclude this so we keep this at about 15 minutes. Please note this is a very abbreviated section of what would normally be about a 2-hour testimony under qualifying, and being a lot more specific and offering the different exhibits along the way. I'd like to thank Brian Hogan, quite experienced in testifying on these cases as well. And this is just to give you a sense of how we would start to testify on the rationale behind Social Security offsets and some of the exhibits that we would like to introduce.
And just a final note, these questions that I've asked today would be questions that we would supply to the attorney who's going to be doing the direct examination. So we would work with them directly, work out all of these questions, answer them, so they have a good understanding of where exactly the testimony is going. It's just something that we do in preparation. We always provide these questions in addition to all the exhibits and everything that we add as well.
And I want to stress one more thing. The most important exhibit to me is actually having one in my hand, but I'd like to go to a whiteboard or to one of our flip charts and show what happens if you don't do the offset, because it's stark. Any court that looks at it, like the Neville court did, okay, when they saw the Social Security covered participant getting $2,000 a month and the spouse getting $1,000 a month, they just saw stark inequality. And this is what we try to show in courts.